Hey, good afternoon, everyone, and welcome to our webinar this afternoon on Partnering to Win, where we're going to be talking about teaming, subcontracting, joint ventures, and mentor-protégé agreements. My name is Sam Finnerty. I am a partner at PilieroMazza in our government contract practice group. I represent government contractors in a wide array of issues, procurement-related disputes, bid protests, small business size and status issues. I also help clients facilitate the resolution of contract claims and appeals they may have, and a whole host of different issues related to FAR compliance and counseling and compliance with small business regulation administered by the SBA. I'm joined this afternoon by my colleague, Meghan Leemon, who is the counsel at PilieroMazza. She has a very specialized practice as well, where she represents a lot of companies, small business companies in different procurement matters, particularly those issues related to eligibility and participation in SBA's different small business programs, such as SDVOSB, Women-Owned Small Business Program, the 8A and HubZone programs, as well as something we're going to be talking about today, which is the mentor-protégé program. She also assists clients routinely in matters related to FAR and SBA regulatory compliance. She also assists a lot and leads a lot of the size protests that we are involved in on behalf of our clients, and she works additionally on equitable adjustments and claims and appeals. So a little bit about our firm, PilieroMazza. We are a full business law firm based out of Washington, D.C., with offices in Colorado, Chicago, and Annapolis. We primarily represent government contractors in a whole host of different issues. In addition to the traditional GovCon work that we do for our clients, we also have a labor and employment, a business and transactions, and a construction practice and a litigation practice that all specialize in sort of the issues that arise within those different industries as it relates to government contractors. Listed here are a bunch of different areas that we specialize in specifically. And I'm going to jump ahead now to what we're going to talk about today, which is a really big topic. It's all about partnering and the different ways that you can set up teams to put a competitive proposal together in the government contract space. So this is an overview of the different topics we're going to touch on today. We're going to start by talking about teaming agreements generally, what they are, what the key considerations are when forming them, what different risks exist. We're going to then jump into subcontracts, which are formed traditionally after you've had a teaming agreement and a contract's been awarded. We're going to look through what the different risks are associated with subcontracts, some of the limitations on subcontracting that apply when you're talking about set-aside work, compliance issues. And then we're going to segue into talking about joint ventures, which are a different way that government contractors can set up teams to go after work. And we're going to close out the presentation today by talking about specifically the mentor-protégé program and some of the rules under that program that impact small businesses and how you can use that program to go after certain set-aside work, specifically how large businesses as well can utilize that program to participate in teams that are going after set-aside programs work. So as I mentioned, the first area that we're going to touch on today is teaming. So it's important to talk about sort of what teaming is. It's an often confused concept where people think, oh, hey, I want to team with somebody, so they're now part of the team. What does that mean? What type of agreement do we need to put in place? How does this all work? There's basically, this is the agreement that you put in place prior to anybody actually being awarded a prime contract. So this is essentially an agreement largely for you guys to team together to prepare a proposal together, which you're then going to submit in hopes that you'll be awarded a contract. Now, why would you want to do this? What are the benefits for the different parties involved? For prime contractors, it can really enhance your competitive posture as you're putting a team together. You've got this opportunity identified and, you have a lot of expertise in this area, but the procurement requires a bunch of different specialized work, and you can bring some of it to the table, but you're going to need some subcontractors to perform different aspects of the work. So if you put a team together and you do this on the front end, you can then tout this team and their different areas of expertise in your proposal to the government, and that might enhance your ability to win the contract. Particularly, as we'll talk about a little bit later, you might be able to rely on some of your subcontractors' expertise, your teammates' expertise, such as their past performance. For example, if you're putting a proposal together and if the RFP requires a certain number of past performance references, well, you might be able to utilize some of the past performance of your subcontractor, which helps you ultimately put together a competitive bid. As a team, you guys are going to share some of the risk of performance. Obviously, the prime contractor ultimately has performance responsibility to the federal government, but if this is a very, this is a procurement where there's different scopes, then you can have the subcontractor be responsible for discrete aspects of the work, and then you guys are going to have a subcontract in place that is going to hold them accountable for their performance. The prime contractor, jumping back one slide, Darian. So for subcontractors, sorry, Darian, we'll back one more slide. For subcontractors, the benefit to teaming is that you can capture new business with less risk because you're going to be holding the subcontractor role here. There's ultimately going to be a prime contractor that's the one performing for the federal government, and they're going to be in the prime position. They're going to have ultimate accountability to the federal government. You might be able to jump on a team and get access to working with a different agency that you might not be able to work with, independently as a prime contractor. And you might be able to go after work that you're ineligible for as a prime contractor. If you're a large business and you want to work on a certain set-aside contract, well, you can't do that as a prime, but you could join a small business's team and you could serve as a subcontractor supporting them for that work. You can go to the next slide now. So this is the sort of the general overview of the steps involved when you're forming a teaming agreement with a partner. So you've obviously got your introduction, you guys meet, you put a non-disclosure agreement in place, you then go through some vetting, you put the teaming agreement in place, you submit your proposal to the federal government, you get awarded a contract, hopefully, and then you put your subcontract in place. So that's the full timeline. We're going to go back to the beginning here and go through it step by step. So most important thing that can get overlooked in the hustle to get a teaming agreement in place, get a proposal put together. Sometimes these opportunities are getting identified on the fly. Teams are being pulled together at the last minute, and proposals are due quickly. So the focus is on putting a proposal together, getting it out the door, and hopefully getting awarded a contract. Critical initial step to the entire process, however, is making sure that you get a non-disclosure agreement in place as soon as possible upon realizing that you and this other company want to discuss an opportunity and you want to share information to start brainstorming how you're going to go after that opportunity. If you don't get a non-disclosure agreement in place, then all the information that you share with that party is subject to being disclosed elsewhere. There might be reasons why you want even the procurement itself to be confidential between you guys, your strategy, just the fact that you're planning on going after something. You might not want to share that information until you get your potential teaming partner to sign an NDA with you, to ensure that all the information you guys exchange can't be used, can't be disclosed outside of the relationship, and can't be used by them in pursuit of this opportunity with another teaming partner. And remember that just because you may have worked with a company before, you might know them well, don't take that simple fact for granted. The relationship is obviously critical, but making sure that you're protected on the front end by having an NDA in place is even more critical. We can jump to the next slide. So the next step, after you get the NDA in place, this is that being the first thing you want to do in an ideal scenario. You then want to go through a vetting process where this is sort of like dating. You want to get to know your teaming partner a little bit better. Make sure you understand who your getting involved with here, and whether this is someone that you want to ultimately enter into a subcontract with and work with for perhaps a number of years on a procurement that you guys are going to have a lot of risk involved in performing together, and you want to make sure that you can rely on this person to carry their weight and hold up their end of the bargain. Part of the evaluation process here is, some of the stuff you can just do on your own. You can do as much research as possible on that company, find public data. You can ask them to share their CPARs with you, the past performance evaluations that they've gotten on prior federal contracts, if they have gotten CPARs before. If they've only ever been a subcontractor, well, then they might not have any CPARs. But if they've been a prime contractor before and they've worked on decently sized contracts, they should have some CPARs. Now, companies aren't always willing to share this type of information, so keep in mind that if you ask for it, you might not get it, and that's a reasonable position in most circumstances for companies to take, because traditionally CPARs are they're just viewable between the contractor and the agency. But ask for them. If companies are willing to share them, you want to know what information is out there about the companies you're going to work with. Ask them for references. Look on social media. Number of different ways you can try to get to know your teaming partner better, because ultimately, if they're included in your proposal and the agency sees their name and does some evaluation related to their role on the contract, if there are negative CPARs floating out there about this company that you weren't aware of, well, that could impact the evaluation of your proposal and could lead to you guys being downgraded and could hurt your chances of winning an award. Jump to the next slide. So what are some of the benefits of teaming for a prime contractor? So the teaming agreement, it really helps to clarify the expected work between the parties, what work share you guys are ultimately hoping to have if the prime contractor gets awarded the contract. It makes it easier to understand the expectations before you guys spend a bunch of resources and time putting a proposal together, only to realize that you don't have a good working understanding of what everyone's expectations are as far as the work share. I mean, ultimately, that's usually the most critical thing that companies are negotiating in these teaming agreements is, subcontractor. Sometimes maybe a subcontractor brings an opportunity to a prime and says, hey, we've done this work before as a sub. We've done really good work on it. We aren't in a position to prime it yet, but we'd like to work with you on it. We've got a great relationship with the agency, but we just want to make sure that, if you get the contract, we get 30% of the work. Well, that's a really big consideration going into a negotiation. And, you really want to know if that's something that they want. That's a good expectation to set up front so that down the road, you don't find yourself in a scenario where you put in all this time and money, subcontractor wants 30% of the work, and the parties are only ever willing to agree, to give you 5% of the work, for example. Also, for a prime, when, sort of along those same lines, negotiating the teaming agreement can be a good precursor and an indicator of what future negotiations with this teaming partner are going to be like. So if you've got a subcontractor that is fly-specking every provision of the teaming agreement and is pushing the envelope on every term and really wants to make sure that they're, getting very favorable provisions, well, then that's not necessarily a bad thing, but you just know that they're going to be someone that's sophisticated and perhaps, they're going to be willing to press their position more so than a company that is perhaps just happy to have a teaming agreement in place and isn't, so interested in ironing out all of those details up front. Can jump to the next slide. Okay. So some more benefits for prime. Key thing to keep in mind here, teaming agreements, and this always raises eyebrows, but teaming agreements are generally unenforceable agreements to agree, at least as it relates to what is honestly the meat and potatoes of a teaming agreement usually, which is the agreement regarding the work share and the fact that you're ultimately going to share part of the work, i.e. issue a subcontract to the subcontractor or teammate. A lot of times teaming agreements have language in them that say things along the lines of the parties will work together in good faith to negotiate a subcontract in the event the prime contractor is awarded the prime contract. That's language that a prime is going to want in there because it creates flexibility. It allows them, really their only obligation there is to negotiate in good faith to give you a subcontract. So, they go into this teaming agreement, honestly, probably wanting to share some of the work with you, but if it doesn't work out and the negotiations fall apart down the road, well, then it's teaming agreement. The fact that it's generally unenforceable as to that work share aspect, that gives them a lot of flexibility to perhaps walk away at the end of the day and, not be held accountable for not actually sharing any of the work with the teammate. That is not to say, however, all aspects of the teaming agreement are not enforceable. There are a number of aspects of the teaming agreement that are enforceable. For example, the confidentiality language in teaming agreements. If there is language in there about, non-solicitation or exclusivity, those could all be enforceable provisions. So this, in theory means that a prime contractor could refuse to issue a subcontract, but they could then still keep their team member exclusive, meaning that that team member can't jump and work for another company if it's if there's multiple awardees here and, the prime decides not to give the contract to the teammate, well, the teammate might want to jump and then go work for one of the other primes, but they could try to enforce the exclusivity against them and say that you can't do that. Of course, important to keep in mind that at the end of the day, if a prime was to know going into the relationship that they had no intent of sharing any of the work with the teammate, then, in theory, that could be fraudulent for them to try and then still hold the subcontractor to an exclusivity provision. Jumping ahead, what are some of the risks for a subcontractor? Well, the other side of that coin is that since the teaming agreement is unenforceable, it's the promise to provide a subcontract with a defined work share. That's a huge risk for a subcontractor. It's unfortunately just sort of a cost of doing business, though, in this space. Many subcontractors think that the teaming agreement is for that very purpose, to get a work share agreement. And they might realize how worthless it actually is, practically speaking, on that point, if you were to try to enforce it, which can, a lot of people roll their eyes when they realize that, but generally, you don't go into a teaming agreement thinking that the relationship's going to fall apart. And there usually is language in there talking about the work share that the parties intend to have and, the discrete amount of work that the prime intends to share with the subcontractor. But at the end of the day, subcontractors need to know that if things go south, it's very difficult to have that work share language enforced. And, why is this? It's because government contracting space is really only the place, really the only place where teaming agreements are this prevalent. You're entering into teaming agreements for usually, these are happening for almost every proposal you're pursuing. If you're putting a team together, enough in advance here. In the commercial space, that's just not really how it's done because you're not often bidding on work in the same, type of context that you are in the GovCon space. So, keeping that in mind, if you did want to make a teaming agreement stronger, if you were a subcontractor, the things you would want to do are you would want to have as many specific terms as possible in the teaming agreement about how the work's going to be done, what the pricing is, and what the different terms of the subcontract themselves are going to be. Some things that companies have tried to do is essentially attach a fully negotiated subcontract to the teaming agreement and indicate that that's the subcontract the parties will enter into the day that the prime is awarded the prime contract. You could try to keep out any language in there indicating that there's going to be a negotiation period, basically anything that suggests that the subcontract might not come to fruition. Again, even if you do all this stuff, there's no guarantee that the work share language itself is going to be enforceable, but there are things you can do to try and make it more enforceable. Okay, final thing we're going to touch on here in teaming agreement space is I want to mention the ostensible subcontractor rule. For small businesses that are going after set aside work, this is a really important rule, and the teaming agreement can be your first line of defense against an argument that you are affiliated with your subcontractor under what's called the ostensible subcontractor rule. As a prime contractor on a set-aside contract, you have to perform the primary and vital requirements of the contract you're being awarded. If you're a subcontractor, and a lot of times it's a large business subcontractor, but if your subcontractor is the one that's really performing the primary and vital requirements of the contract, well then under what's called the ostensible subcontractor rule, they can be deemed affiliated with you. And this is the same if the circumstances show that the prime contractor, the small business here, is unusually reliant on its subcontractor to perform the contract. The reason you want to avoid this is because if you're affiliated with your large business subcontractor or your small business subcontractor, and that affiliation causes you to be large when your size is calculated, well, then you're ineligible for the procurement. And if someone files a size protest or a status protest against you, you're not going to be eligible for the set-aside opportunity you went after. So your teaming agreement, and during these reviews, when these protests come out, SBA asks for the teaming agreement between the parties, if there is one, very often. So your teaming agreement, if it's drafted well, can be your first line of defense against this type of allegation of affiliation, because if it clearly maps out that the prime contractor, not the subcontractor, is going to be performing the primary vital requirements and it's going to be managing the contract, and those are all factors that would go against the finding of affiliation. Now, one final point here is that this ostensible subcontractor affiliation concept doesn't apply to similarly situated entities. So if you're a small business or an SDVOSB, for example, and you're going after a small business or an SDVOSB set aside, if you subcontract a lot of that work or subcontract the primary and vital requirements of the contract to another small business or to another SDVOSB, well, then there can't be a finding of ostensible subcontractor affiliation between those two parties. So that's okay. But if you are subcontracting out the primary and vital requirements to a large business or a non-similarly situated subcontractor, that's going to be problematic, and it could lead to your ineligibility for the work. So my colleague Megan is going to now talk about subcontracting.
Thanks, Sam. So the next step in this whole process is after you do the teaming agreement, you submit your proposal, and then ideally you have been awarded a contract. So once that occurs, the next step typically is that the parties will enter into a subcontract. So we're going to talk through some of the provisions that we typically include or recommend including in the subcontract itself. So you would typically carry over as many provisions from your teaming agreement as possible. There may even be a section in your teaming agreement that says, you know, our subcontract will include provisions A, B, C, D, E, F. So you'll go through it and make sure that you include the same types of provisions, not just regarding the work share, but if you have something in your teaming agreement that says we'll include a non-solicitation provision, will include the same performance of work period that applies to the prime contract. The possibilities are more or less endless in terms of what you include in your teaming agreement that then gets carried over. But you want to make sure that anything you've agreed to in the teaming agreement that will carry over is actually carried over. Typically, the subcontract is more detailed in terms of the performance of work and who's doing what. Particularly for task order type or IDIQ based contracts, you may not know. You might still have a general idea of the type of work that each company is going to perform, but until you're issued task orders, that might not be, you know, super specific. But as specific as you can be in terms of the specific scopes of work, statement of work, you know, maybe paragraph references, numbers in terms of who's doing what, exact percentages, dollars, that's all very important to include in the subcontract so there's no question about who is doing what. Like I said, you want to identify maybe which sections of the statement of work are applicable. But it's also important, just like the teaming agreement, to make sure that the prime contractor, especially on a set-aside contract, is the one that's in control of the contract the arrangement, performance, and so forth. So in addition to asking for a teaming agreement, if there was a protest, SBA would also ask for a copy of any subcontract if you'd have entered into one or anything along those lines. The key is to make sure that the performance of work requirements are being met, and that the prime is really the one controlling the contract. I mean, ultimately, they are the ones that are on the hook for performance. So it's important that the small business, 8A, what have you, retains discretion over the subcontract as well as performance. There might need to be some adjustments that have to get made. I think a lot of people tend to push the 51-49 percentage split, assuming you have one subcontractor, pretty closely. But given, kind of some of the unknowns with invoicing and certain, types of dollars or what's included, what's not, you want to make sure you're not like maybe, exactly right there. Just give yourself a little bit of wiggle room. The subcontract also typically includes a number of flow down provisions. Depending on the prime contract, there are certain provisions, FAR provisions that must be flow down. But then there's also provisions that the prime may or may not flow down. So it's important to include those and review to see, okay, does this make sense to flow down? Am I missing something? Things along those lines. You also want to identify, just make clear who has like the primary, responsibility for communicating with the agency. That should generally, again, be the prime contractor. So who's doing that? Who's doing what? Who has what authorities? As specific as you can be to define these will help ensure that your subcontract and performance of ultimately the prime contract goes more smoothly. Keep in mind, do you want to include a provision regarding assignment or lower tier subcontracting? So if you have a sub and the sub then wants to further sub down to a second tier or lower subcontractor, do you want to be able to allow them to do that with or without your approval, and vice versa? Keep in mind for that as well that 1099s, independent contractors, are considered subcontractors. So if you're hiring a company and then they plan to go hire a bunch of ICs to do the work, depending on what your subcontract says, that may or may not technically require approval of the prime in order to do that. So keep in mind how you want to address that in your subcontract. Again, we can't stress this enough to carefully define the duration. How are options going to work? Modifications, extensions, follow-on. You have a number of different options. There is no, right or wrong answer. Do you want the subcontract to automatically extend if the prime contract, the option is exercised by the government, or do you not? Do you want to come to an agreement on, typically an annual basis or a period by period basis? Whose discretion, who has that authority? Is it a mutual? Can the prime just automatically extend it? What do you want to do there? And again, it's important to kind of maybe have these discussions through the teaming agreement process so that you're not completely caught off guard when you go through the subcontract. But we understand that the teaming agreement often is rushed, necessarily so sometimes given the nature of the procurement. But these are all things to think through. And have careful wording, in terms of, to make sure sometimes the subcontract is open to interpretation, and then obviously that makes it a lot more difficult. Is it getting extended? Is it not? If the agreement is pretty clear that it's automatically extending when the government exercises an option, then that's that. You move forward, everything is fine. Make sure to identify any particular deliverables that are the responsibility of the subcontractor. That have to then deliver it to the prime and then to the government. How is that going to be hashed out, detailed? Termination is obviously a very big clause to include. If you're a prime, you may not want to just necessarily include the FAR termination clause that's included in your prime contract, because you want to make sure that you're protected as the prime as well. I mean, the government has a right to come in and terminate you for convenience at any time. Do you want to have a similar right with your subcontractor? On the flip side, if you're a subcontractor, you obviously don't want the prime to be able to come in and terminate your for convenience for any reason. So there are negotiations on that aspect as well. You know, should it be limited to situations only where the government has terminated the prime contract for convenience? What is kind of the driving force here? How do you want to handle termination for cause or default? You know, what type of cure period do you want to provide, if any? These are all things to carefully think through and define in your subcontract. So it's definitely going to be much more robust than your teaming agreement. But to the extent you can kind of hash some of these details out earlier rather than later, again, everyone will be on the same page. How do you want to handle disputes? What choice of law? Typically, it's the same state where the prime contractor is located, but it doesn't have to be. Where do you want to handle suits? Do you want to do it through court, or would you prefer a mediation or arbitration? Those are all things to think through as you're drafting the subcontract.
Yeah, so some other terms in the subcontract that you want to account for. You want to identify the billing rates for your subcontractor personnel. That's critically important. Obviously, figuring out what the payment terms are going to be is one of the key terms of a subcontract. Primes are going to want the right to review their subcontractor employees that are proposed to fill different positions, and they're going to want the right to replace any individuals that are unqualified. So that's usually an area for negotiation, whether and how subcontractors' personnel are replaced. Usually the subcontractor is the one that has the management and oversight authority over how exactly their personnel perform, but a prime is going to usually have, and the prime contract itself is very often going to have specific qualifications of different personnel, years of experience and things like that, educational requirements. And so the prime is going to want, that assurance that they can vet, review subcontractor personnel and replace personnel that either aren't up to the qualifications or that aren't performing. Primes may often want the right to inspect and reject goods and services that don't conform to the terms of the subcontract. And oftentimes there'll be a provision included in a subcontract that indicates that the government ultimately has the right to inspect the subcontractor's work and facilities if needed to ensure compliance with the terms of the prime contract.
I'm back and I can see the slides. Thanks, Sam.
Yep.
Sorry about that. So continuing on, again, just kind of going to this overarching theme of defining, the specific terms and making sure you've covered everything. Define when payment is due. Are you going to be doing a pay when paid clause? Are you paying net 15, 30, 45, 60? How are you going to handle that? What is the procedure for submitting invoices? Typically, it's due 4 or 5 or so days after the first of the month. You want to make sure, if you're the prime, that you have sufficient time to review your subcontractor's invoice to make sure that you are able to include that in your invoice that you then turn around to the government. Typically, travel or per diems are not included. I mean, it could be depending on the nature of your prime contract. So obviously address that on a case-by-case basis. We typically include a right to audit, where the prime can come in and audit the subcontractor's files, and also that the government might have that ability too if they want. What happens if the government disallows costs that the prime subcontractor costs that the prime has passed through? What is going to happen? Typically, the prime would then withhold future payments, until that is resolved. Do you want to do an escrow? So do you want to essentially assign the money that the prime receives over, and then an escrow agent will have to pay that out? Those are all kind of things to think through. That is not common. It is possible, especially if the prime maybe is a little bit less established, but that is not super common. You also want to discuss disputes, and not just necessarily disputes between the parties, but also disputes with the government. in terms of disputes between the parties, so the parties to the subcontract, do you want to include strict limitations on liability? So for example, the liability, to the extent there's a breach, what have you, the liability is not going to exceed X. Typically, it's the amount paid under the subcontract, but I mean, you could do whatever you want there. But if you're the one that has caused whatever issue, then that potentially means, that you're only liable up to that certain amount. There's not additional like lost profits, consequential damages, things along those lines. How do you want to handle an indemnification provision? Most commonly, this is definitely mutual, but primes try to push for one-sided indemnification because the risk more so is on the prime. The prime ultimately is the party that's responsible for performance of the contract to the federal government. The government doesn't typically, they don't have privity of contract with the subcontractor. They can't come after you. So keep in mind, does it make sense to have indemnification be mutual? Do you want to limit? If you do have court, do you want to include a jury trial limitation? We typically include a waiver of a jury trial, less expensive, less timely, all of that, but there might be a reason why you would want to have a jury trial. Over and beyond disputes just between the parties to the subcontract, you also want to address disputes with the government, particularly if you're the subcontractor. If you have an issue because either there's a contract interpretation or there's been a change that directly impacts your work and you need to file an REA or a claim, you as a subcontractor do not have the ability to do so, under your own name. It has to be submitted by the prime because they're, again, the one that has the privity of contract with the government. So how are you going to define this process? Who's paying for it? What oversight does the prime have? Are they sponsoring you? Are they going to, let you submit it on your behalf, which they might not be able to do because the government will want the prime to submit it on their, through their own name. Typically, we would provide that the subcontractor must pay. They can use their own counsel, but it's subject to oversight as the prime because the prime shouldn't be certifying a claim that they haven't reviewed, don't agree with, so forth. So it also potentially, the claim or the REA or what have you could impact both parties. So both the prime and the sub. How are you going to handle those disputes? It's important to hash these out again now so that to the extent this arises, which it very much can, especially in a construction contract, but not, really in anything, to make sure that this is handled. So in terms of just subcontracting compliance, you are probably all aware for a set-aside contract, there are certain limitations on subcontracting. For services or supplies, the limitation is 50%. So you can subcontract up to 50%. Typically, companies tend to go 51-49, but the rule technically is 50%. For construction or specialty trade construction, it's a 25% self-performance requirement or a 75% limitations on subcontracting. For general construction, you can subcontract up to 85%, but you have to self-perform 15% of the work. That includes like any subcontractor other than similarly situated subcontractors. So if you have a similarly situated subcontractor, that counts as work performed by the prime. So if you have an 8A contract and you want to sub to another 8A, they would more than likely count as similarly situated so long as they're small under the NACE code that's assigned to the subcontract, which does not have to align with the NACE code that's assigned to the prime contract. So if there's a discrete scope of work that's kind of being peeled off for a subcontractor, and that really falls better under a different NACE code, that is probably the more appropriate code that you should be assigning to the subcontract. And then that is the standard that they would be measured for if they're small, under, or not. And that potentially could have a higher size standard. So keep it then the prime contract. So keep in mind that it is possible to use a similarly situated, even if they might not be small under the NACE code assigned to the prime contract, as long as they're small under the names assigned to the subcontract. Another big piece, again, kind of though, depending on the type of work that you're performing, is making sure that you protect intellectual property. And how is the IP handled in your subcontract? You want to make sure that any preconceived IP is not, essentially covered, or what is excluded from any potential rights that might pass to the prime or potentially to the government. However, if you're doing a prime contract, the government generally owns the IP and requires that certain rights transfer to them, and that needs to get flowed down to the sub. And if that's not clear and there's a dispute over that, I mean, you could potentially be in a very sticky situation. So you want to make sure, especially if this is important to the type of work that you're performing, that whatever you can protect is protected, but then also whatever rights are needed to pass are passed. And now we're gonna, with the little bit of time we have left, we're gonna talk about joint ventures and mentor-protégés. I'm gonna turn it back over to Sam.
Yeah, thanks, Megan. I'll try to move through some of this quickly. So joint venture is another way that partners can team to pursue different federal opportunities. We've been talking about, a traditional prime sub relationship so far, where you put a teaming agreement together and then that gets, replaced by the subcontract once the award's made. Totally different way to go after an opportunity with a team is to create a joint venture. So general rule being, if two companies form a joint venture, they are generally going to be affiliated for purposes of that opportunity, meaning that they would not qualify if, for the NAICS assigned to that, if it was a set aside, if together their receipts or their average number of employees exceeded that size standard. Now, the caveat is that SBA has implemented regulations that allow small businesses and large business mentors and their small business proteges to form joint ventures and to still go after set-aside work and to not be deemed affiliated for purposes of that work, provided they comply with different joint venture regulations. So that being said, SBA generally considers a joint venture a limited purpose entity that's formed to pursue work for a certain period of time. That time is commonly 2 years, but there's some caveats there. Basically, a joint venture that is formed can receive a contract. A joint venture that is formed, once it receives its first contract, it can then submit additional offers for as many contracts as it wants for a period of 2 years. And provided it doesn't submit any bids after that 2-year period expires, then it will continue to qualify as small. If it submits a new bid after those 2 years, then it will no longer receive this sort of exemption from affiliation, and it will be deemed, partners will be deemed affiliated, and it'll likely, provided it exceeds the size standard, it will be ineligible for work. So that 2-year period has some additional definitions to it as well. You can certainly a joint venture can accept a contract award after 2 years from its first contract award, provided that it submitted its proposal for that contract within the 2-year period. And the other caveat here is that for multiple award for task order contracts, each individual task order isn't a new contract, at least for purposes of this rule, meaning that once the JV wins a task order contract, it can continue to bid for the life of that contract and bid and be awarded all of the task orders they're under without needing to worry about being outside of the 2-year bidding period. A joint venture is not a CTA, not to be confused with a CTA. That's a term of art that GSA uses for schedule contracts. And the other thing here to note is that a joint venture doesn't just have to be between a mentor and protege. You can also have small business joint ventures, which we'll touch on a little bit more here. You jump to the next slide. So why would you want a joint venture? Well, there's a number of different reasons. One of which is that when evaluating a joint venture that's submitting a proposal, the government has the ability to look at the resources of 2 or perhaps more companies that are going to be performing the work through this joint venture. There's rules that SBA has that says the government has to take into consideration the past performance, the work, and the qualifications of all the joint venture members. When it's talking about a set-aside contract here, there's some ambiguity exactly around what consider means. There's been some recent case law that's come out around that point. But the big takeaway is, without getting too in the weeds here, is that when you joint venture, unlike traditional prime sub, you have more opportunity to be pooling your resources, your qualifications, your past performance, and having the agency evaluate those. Whereas in a prime sub, there can be a lot more restrictions on what the agency has to evaluate at the subcontract level and what qualifications the prime contractor specifically itself has to hold. In a joint venture, unlike a prime sub relationship, the minority joint venture partner can exert more control than they otherwise would be able to do if they were just a subcontractor. This is because, normally joint ventures are organized as separate legal entities. They're often formally organized as limited liability companies. So you actually have, an operating agreement for this entity that has a number of business provisions that establish how this joint venture is going to be managed and operated. And that obviously gives the minority partner more say in the actual structure and performance of the joint venture than it would when it just has a subcontract and its prime contractor has a contract with the government. It also allows a joint venture member to participate in a contract that it otherwise would not be eligible for. So this is, if you've got a small business joint venture, that's a joint venture between all small businesses, and the managing member of that joint venture is, for example, an SDVOSB, and therefore the joint venture can qualify for SDVOSB work, and the other small business members of that joint venture that aren't SDVOSBs, well, they're now able to compete for this SDVOSB work through their joint venture when they otherwise wouldn't be able to do that. The more traditional example is when you have a mentor-protégé JV between a large business mentor and its small business protégé. Well, that large business mentor can now form a joint venture and with its protégé, and it can go after set-aside work that it would not be able to go after on its own as a prime contractor. One of the other really big benefits of joint venturing for companies that are growing and trying to plan for future growth and keep their size status longer and not wanting to exceed a size standard. Well, when you joint venture, you only have to attribute the revenues on the joint venture's prime contract in a manner in which each JV partner puts onto its books the revenues associated with its work share of work performed by the joint venture. Whereas in a prime sub relationship, if you're the prime contractor and you get awarded a $5 million contract, for size purposes, that's $5 million on your books. But if you're in a joint venture and you only perform 50% of the work, well, then you're only going to have to put $2.5 million on your books towards your size. So that can have big implications as your company's growing and getting up against its size standards. Jump to the next slide. Big thing, however, with joint ventures is that compliance is key. You have to comply with the regulations. What does this mean? This means that if it's a small business joint venture, not mentor-protégé, this means that all the members in the joint venture have to be small under the NAICS code assigned to the procurement, unless if you're pursuing a JV with your mentor, then the mentor is obviously in most cases large here. In that case, you can qualify so long as the protégé itself is small under the NAICS code and holds, if it's a specific socioeconomic set aside, they also hold that designation. The majority owner has to qualify for the type of set aside. So if it's all small businesses, like I alluded to earlier, and you're going after SDVOSB work, then the managing member has to be an SDVOSB. If the JV is formed as a separate legal entity, which is often the case, then it can't be populated with individuals that are going to be actually performing the contract work. But the JV could have employees that are performing just administrative work. So this can help your joint venture obtain facility clearance if that's something you want to do, because in that case, you've got to have an FSO, and that individual could actually be employed by the JV You could also have certain admin, non-contract billable folks employed by the JV that are assisting the operations of the JV, but not specifically working on a contract. So like I mentioned earlier, JVs are qualified for 2 years after the first award to the JV. Just keep in mind when figuring out whether you comply with this rule, novations are considered awards. So if the contract is novated to a JV, that is the first contract, that is going to be considered the first contract to the JV, even though it wasn't initially awarded to the JV. And I already touched upon these other 2 points earlier, so we can jump ahead. So the other big part of compliance here has to do with performance of work. So there are both internal and external performance of work requirements for joint ventures. The joint venture has to perform, depending on the type of work, whether you're talking about services or construction work. The JV has to perform at least either 15, 25, or 50% of the work on the contract, and the other percentages can be subcontracted to any firm. When calculating the work that the JV is performing, you use all of the members' work combined, and that, then that percentage is how much has to comply with those figures I just mentioned. That's external. So that's how much of the contract itself the JV has to perform. And the internal performance of work requirements, these are the percentages that the qualified member of the JV has to perform. So in the case of a small business joint venture with all small businesses, and it's going after SDVOSB work, and it's got an SDVOSB managing member, well, in that case, the qualifying member is the SDVOSB managing member. They have to perform 40% of the work that the JV performs. If we're talking about a mentor-protégé JV, the protégé has to perform 40% of the work performed by the JV. So, we'll use a services contract as an example. If the JV decides to perform 50% of a contract, then of that 50% that it performs, 40% of that 50% has to be performed by the protégé or the otherwise qualifying member. And this internal performance of work requirement cannot be met by subcontractors, even if they're similarly situated. So a protégé that's an 8A, for example, can't subcontract out some of its work to satisfy this 40%. The period for measuring these internal and external performance of work requirements is period by period. So it's not the full life of the contract. It would be, for example, the base period and then each option period. For IDIQ contracts, it is across all of the task orders per period of performance. So again, all task orders issued over the base and then the option, unless the contracting officer specifically indicates that it's going to be measuring the performance of work requirement on an order by order basis. If that's the case, then you have to comply for each order, which obviously makes, figuring out which members are going to perform which orders and how you're going to subcontract, it makes all of that much more complicated when you need to comply on an order by order basis. How much work the JV performs is calculated by adding the work from all JV members, like I mentioned, but it also includes work done by affiliates of JV members. So if a mentor is going to be doing some work and then it has, a subsidiary that's an affiliate of it that's going to be subcontracting some of the work, well, that's going to count for purposes of figuring out how much work is being performed by the JV itself. So just keep that in mind. You can jump to the next slide. So some more notes here on compliance. SBA is now looking at the JV agreement and comparing that to your proposal during size protest. So if they don't match up, that could be a problem if you find yourself facing a size protest. The elements of the applicable JV regulations all need to be met in the JV agreement. So if you're going after socioeconomic set-aside through a small business JV or any type of set-aside through a mentor-protégé JV, your JV agreement needs to check all the boxes. That means that the JV agreement itself needs to include a number of discrete provisions that are mapped out in SBA regulations that are critical. And if those are not included in the agreement, then the JV doesn't qualify as a eligible JV for the set-aside work it's pursuing. There is a new SBA final rule that goes into effect in a few days. The language here that's not bolded is how the regulation currently reads. It indicates that the managing venturer has to be responsible for day-to-day management and administration of the performance of the JV on its contracts, but that other partners like the mentor or other minority partners can participate in corporate governance activities and decisions of the JV that are commercially customary. Spent some ambiguity on what exactly that means, because a lot of the back and forth negotiating JV agreements is on the provisions related to the approvals required of mentors and minority members who want to have some say in the operation and management of the company. Since they're invested in this company, they're a part owner of it. They'd like to be able to, have some authority over how decisions are made. And there's been a lot of ambiguity about which provisions are permissible for those types of partners to have a say over. And there's been some case law that's developed recently that has added a little bit of clarity to this. And in response to that, FBA has implemented some changes to its regulations, and the bolded provision here is now being added to the regulation to indicate that a JV agreement to qualify cannot give a non-managing venturer negative control over activities of the JV. And negative control is like a veto power, basically. If you can block action of the JV, or you have, a veto power over, action of the management committee or something like that, that's impermissible unless those provisions, the things that you have veto power, negative control over, would otherwise be commercially customary for a JV agreement for a government contract outside of SBA's programs. So that, introduces a lot of flexibility. In theory, introduces some flexibility here as to what types of things are permissible if you can establish that they're commercially customary outside of SBA's set-aside programs. Also importantly, the regulation goes on to provide that a non-managing venture's approval can be required to determine what contract opportunities the JV should pursue, and if any decision by the JV to initiate litigation. That's critical because previously there have been some confusion there. There have been some negative case law indicating that, a non-managing venture or a minority venture was just kind of along for the ride. And other than perhaps, being involved in the decision to form the JV and pursue contract number one, it didn't get to have any say in the JV's pursuit of contract number two, but it would be, in theory, bound to perform contract number two. So this adds some much needed clarity to the rules. Other things to keep in mind for JV compliance: the JV agreement has to be finalized and signed prior to submitting the proposal. If it's not, then you are not going to be eligible if someone files a size protest. The JV itself also has to be registered and active in SAM as a JV as of the date that you submit your proposal. As far as the JV agreement itself goes, you need to have this finalized and buttoned up, properly negotiated, dotting all your I's, crossing all your T's, but SBA is not actually going to review it or approve it for any type of procurement except for an 8A sole source award. So it's up to the parties to make sure that if someone comes knocking and shines the light on the agreement, that it passes muster, because there's not a pre-approval process outside of the sole source 8A context. So some other joint venture issues, I already sort of alluded to this. Revenue for size purposes is split commensurate with the work performed, or ownership if you're talking about employee-based NAICS codes. So like I said, you're never going to be attributing 100% of the employees or 100% of the revenues to yourself if you're splitting work like you would in a prime sub situation. Profits are split the same way, but that's not really that relevant because usually joint ventures are pass-through entities, so they don't have any profits. A note here on construction: for construction JVs, it might not really make sense to be forming JVs in certain situations, because in a prime sub, a subcontractor can perform up to 85% of the work, but through a JV, the mentor still has these internal performance of work rules. So that would actually mean that they would not be able to perform as much work through a construction JV as they would be able to perform if they were the sole subcontractor on a construction contract and performing up to 85% of the work. Jump to the next slide. So final note on joint ventures here, kind of, you know, that they've been really a topic recently with some of these big procurements that are coming out, where JVs can take advantage of a bunch of different members, different types of experience, past performance, and other qualifications. STARS 3, CRSP 4 have been in the news a lot as far as how those solicitations are set up and how they allow joint ventures to put these, you know, like super teams together and to pool all their resources and experience. But these solicitations still require, you know, something from the managing member other than just its socioeconomic status or its, you know, its size status, it's the mentor-protégé, something like that. The problem, and it's something to keep in mind though, is when you're putting these large teams together, performance of work can be really difficult to figure out how to comply with that. If you've got these big IDIQs and you've got each member from the JV bringing something different, a different skill set to the table, indicating that, you know, we're going to do all these types of orders when they get issued, and company B is going to do all these types of orders when they get issued. Well, it's hard to plan for the future. What happens if all the work you win ends up going to an area where, you know, it's the non-qualified member that's performing it. It's not the managing member, and then you're immediately out of whack with your performance of work requirements, your limitations on subcontracting. If it's the managing member that doesn't have the expertise to perform order number one, and instead, you know, one of the other venturers has to perform all of that, well, then you're not going to be able to comply with those internal performance of work requirements. So that can lead to some tricky issues. So just, you know, food for thought as these big procurements continue to gain steam and these teams continue to get larger on some of these opportunities. Jumping ahead, Megan is going to touch on CTAs and take us through mentor-protégé.
Thanks, Sam. Yeah, I'll quickly run through. We only have a few slides left. So we often get this question about, you know, can I form a CTA? Well, as Sam mentioned earlier, a CTA really is a term of art that GSA has kind of coined in its schedule world. So are you forming a team to bid on an order under a GSA schedule? That really is a CTA. While the FAR uses like the term contractor team arrangement, that really is either a joint venture or a prime sub. There is no like separate third CTA option in non-GSA procurement. So it's often a point of misconception, largely because agencies tend to use this term CTA in their solicitations when that's not really, you know, what they mean. They're really referring to FAR 9601 arrangements, there are two options, prime sub or joint venture. For GSA CTAs, that is something that is, again, specific to GSA schedules specifically. And in that particular case, each company to the CTA is considered a co-prime. You're not a subcontractor, you're not a joint venture, you're essentially a co-prime to the agency. This is not something that's recognized like in the FAR or by SBA. It's something that's done specifically for GSA. So it's important to just be mindful of the different terms of art and how they're used. For a GSA CTA, like I said, there's no laws or regs. It's just GSA has issued guidance on what they want to include in the agreement. The CTA is typically included with your proposal, so the agency reviews it and sees if there's issues that, you know, things that they have issue with or not. SBA does not acknowledge the CTA concept. Again, it's either you're a prime sub or you're a joint venture. For GSA CTAs, though, if you're bidding, you know, on an order under a schedule, every party to that CTA needs to share the same socioeconomic status for that particular order. So if there's an order that's being set aside for women-owned small businesses under a GSA schedule, both companies, or you can have CTAs of more than two, but just assuming there's two, both companies must hold the schedule necessary to bid on that work and have that WOSB designation. So you want to make sure if you're forming a GSA CTA that everyone shares the same size and status, which is not the same for if you were forming a joint venture. The CTA itself is subject to the performance of work requirements. And in terms of revenue, typically, though, even though each company is a co-prime, there's typically one team lead, and the agency will issue orders to typically that team lead, but there's potentially the option to have orders issued to other companies if they are going to be performing the majority of the work. So you will take on your revenue commensurate with like the full orders that you're awarded. So you don't get to take out the bit that a subcontractor performed or commensurate with work performed. So you kind of just want to be mindful of the different rules and how these impact your size. Lastly, on mentor-protégé, SBA recognizes, obviously its mentor-protégé program. There is no longer the all-small program, although I think that's what people typically refer to it as. A couple years ago, SBA merged their 8A and all-small program, and now it's just simply the SBA mentor-protégé program. As you may be aware, there are other agencies that have specific mentor-protégé programs. It's still a little bit, kind of gray area in terms of how that potentially could impact other opportunities. But for purposes of this, we're just focusing on SBA's program. So you apply, it's about a 90 to 110 day approval review process. If you're denied, there is no longer a reconsideration process. You do have to wait to reapply, unfortunately. To be a protege, you have to be small under your primary NAICS code, assuming that's the NAICS code that you want to assign to the agreement. You also have the ability to seek approval of the agreement under a secondary NAICS code. However, if you go under a secondary NAICS code, the protege has to demonstrate work that they've done in that secondary NAICS code, and that you're small. But you don't necessarily have to be small under your primary if you're seeking approval under a secondary that you've done work in and that you're small under. Generally, a protege should only have one mentor at a time. But you can have only up to 2 in your entire lifespan. So SBA did add a couple years ago an annulment process that if the agreement is terminated within 18 months from the time that it was approved, then it may not count as one of your 2 mentors. That's not like a hard and fast, okay, we terminated within 18 months, we're good to go, we're annulled if this doesn't count kind of thing. SBA looks at the circumstances. Was there significant benefit? Did you enter into a joint venture and bid and win a contract, and now all of a sudden you want to terminate the agreement within the 18 months? Is it equitable essentially to annul that agreement or not? So don't rely on this 18-month thing as, the end all be all. But typically you're limited to 2 mentors in your lifetime. SBA also recently clarified that you can use your second mentor relationship with the same mentor. So if things have gone really well over the 6 years and you want to do it again for another 6 years, go for it. You do have to provide a new application and new agreement showing how the assistance has evolved, because presumably the protege should be in a different spot, than it was 6 years ago when it originally entered into their relationship. So you want to show that evolution, but you are able to use both of your relationships with the same mentor. As a mentor, you could be small or large. A mentor does not have to be a large business. There might be a very good reason why a mentor who's a small business wants to enter into a mentor-protege relationship if there is an affiliation concern. Because if you're providing assistance to a protege through a mentor-protege agreement, then that assistance is covered from an affiliation analysis. So there's definitely a reason to enter into a mentor-protege agreement, even if your mentor is a small business. The mentor has to show commitment and that it's capable of providing the mentoring, has to possess good character, must be for profit. The mentor can only have up to 3 proteges concurrently. And SBA recently clarified that this applies to the mentor family of companies, so a parent or a subsidiary. You have to include the limit of 3 across the life of the mentor. So you couldn't just have a mentor have a bunch of subsidiaries and then they go and get 3 proteges and then a mentor as a family has, 6, 9, 12, what have you. It does apply across the board. You also have to demonstrate that there is no competition or conflict amongst the other proteges. So SBA will not approve an arrangement where you're entering into a second or third mentor-protege relationship where that protege is a competitor of your first protege or second. They want to make sure you as a mentor are not put in a situation where you're picking and choosing one protege over another. So essentially you should be entering into relationships where that is not a possibility. You're going to be pursuing different opportunities, you're helping them with different work and so forth. While you're limited to 3 concurrently, you are not limited to any set number over the lifetime. Like I mentioned, the term is 6 years in one relationship. It used to be like a 1 year renew annually, then it was 3 years or do another 3. Now it's just 6 years. SBA realized that was causing a lot of confusion. So it's just 6 years, unless earlier terminated. Either party can terminate the relationship, including SBA, with 30 days notice. You want to make sure you guys are on the same page and continuing. Lastly, in terms of how this relationship continues, you do have to provide an annual report to SBA every year about the mentor-protege program. What did you guys do during the last year? How did everything go? The protege should definitely provide an honest assessment. I've heard too many times a protege saying, well, our mentor really hasn't done anything. We're really annoyed. They haven't helped. And then I asked, well, what did you say to SBA? And they said, oh, well, everything was fine. I was like, okay, well, you need to give an honest assessment. SBA has the ability to come in to perhaps substitute. They could step in and say, hey, mentor, you need to do what you said you were going to do. Otherwise, we're terminating this relationship. So there are definitely risks to not doing that, not providing the mentoring. And as the protege, you want to make sure, ultimately the program is there to help you and is designed to protect you. So you want to make sure SBA is aware of everything that's going on. I know that was a lot, and I think I was able to get through most questions while Sam was speaking. But if we didn't get something answered, feel free to email either Sam or I, and we will get back to you.
Excellent. Thanks everyone for joining.